Greetings, YouTube. Today I'm going to be talking about sovereign citizens. Now, to give people who don't know what a sovereign citizen is, I'm going to read a synopsis here from the rationalwiki.org that covers a particular topic. Sovereign citizens typically believe that there are two types of citizens, natural citizens and 14th Amendment citizens, based on idiosyncratic readings of the Declaration of Independence and Bill of Rights. They believe that natural citizens are citizens of the United States by virtue of having been born in one of the 50 states, not including the District of Columbia, having renounced his U.S. federal citizenship and contracts, a term of art used exclusively by sovereign citizens in this context, and filed a quote-unquote quiet title. Actions to quiet title always relate to his disputes about the ownership of real property and certain title chattels, so that the notion of quieting title to a human being is unknown to the law. Sovereign citizens believe that natural citizens are not subject to any United States federal law, including being subject to the jurisdiction of federal courts, but are subject to natural law and common law. By contrast, 14th Amendment citizens are subject to federal and common law, but can become sovereign citizens by taking the same actions as sovereign citizens. In the United States, the sovereign citizen movement is closely related to the Posse Comitatus and Freemen on the Land movement, and there is a substantial overlap between these movements and militia movements. Many sovereign citizens believe that only white men have rights because only the Constitution and the Bill of Rights apply, not any subsequent amendments. Thus, they believe the ratification of the 13th Amendment, abolishing slavery, is unconstitutional and of no effect. They may also believe that the 19th Amendment is unconstitutional, meaning women never gain suffrage in any election in which women vote is null and void. Though a few stateless people exist in the world, most in permanent diplomatic limbo due to the lack of any citizenship, and in the United States a few have somewhat arcane legal status allowing them to be citizens of their place of residence, including currently recognized only in America, Samoa, and Swains Island, but not the U.S. at large. The idea that one can renounce one's citizenship in order to evade the laws of the land is unknown in all countries, and the U.S. courts have uniformly found this argument frivolous. So you can well imagine that this is an interesting group of people. So on to the article at large, and this is from the ABA Journal, and it is titled the article title is Posner informs pro se litigant that the Queen of England did not absolve him of a need to pay taxes. This is a short article. I'm going to read it because I happen to have a deep and abiding love of Judge Richard Posner. Judge Richard Posner is countering a pro se litigant's sovereign citizen type arguments with a history lesson and a warning. Though Posner is an appeals judge with the Chicago-based 7th U.S. Circuit Court of Appeals, that's a mouthful, he likes to volunteer for trials. He has drawn the case of Hakeem El-Bey, who is accused of defrauding the Internal Revenue Service above the law reports. In an order issued on Friday, Posner warns El-Bey that he will forfeit the right to represent himself at his March 2nd trial if he continues to inject utterly irrelevant and patently inaccurate and sometimes unintelligible contentions in this case. Posner writes that he has already appointed a standby counsel for El-Bey, who, despite his arguments, strikes me as an intelligent person, and he has been unfailingly polite in pre-trial conferences. Posner previously warned El-Bey in person and in a February 12th order that he should not try to introduce arguments or testimony about the Uniform Commercial Code and the Federal Rules of Civil Procedure, Admiralty and Maritime Law, or the Foreign Sovereign Immunities Act. These bodies of law are totally irrelevant to this criminal prosecution, Posner writes, nor may he argue that the trial that his court lacks jurisdiction over him because he is a sovereign citizen or a citizen of the Cherokee Nation. He is in fact a U.S. citizen, that the U.S. government is a corporation or is insolvent, or that the Internal Revenue Service has been dismantled. Despite the warning, El-Bey has continued to make additional irrelevant arguments, Posner writes. His new court filings assert that the U.S. government owes El-Bey $367,500 in redemption of damages. Elbay also claims that a Stamp Act treaty with the Queen of England had imposed taxes on alcohol and cigarettes, but it exonerated Americans of the need to pay all other taxes. Elbay got this history wrong, Posner writes in his order, and this is one of the reasons I love Judge Posner. The Stamp Act was enacted by the Parliament of Great Britain in 1765, Posner wrote. It did not relieve Americans of any taxes. On the contrary, imposed a comprehensive tax on the use of paper by Americans. The act was not a treaty between Britain and the federal government of the United States, for there was no United States. There was just 13 British colonies that 11 years later proclaimed independence from Great Britain. There was no federal taxes that the act could have relieved Americans from having to pay. The sovereign of Britain at the time was a king, not a queen. The king's wife, Princess Charlotte of Mecklenburg-Strelitz, something new to me, was Great Britain's queen, but had no governmental authority. And this is why I love Judge Posner, because he not only is he very smart and very well spoken, but he dismantles people's arguments in an unfailingly polite manner. He doesn't dismiss them out of hand. And one of the reasons I love Judge Posner is he has been an outspoken opponent to the whole voter ID laws, which I consider to be an attempt to undermine the voting rights of American citizens, and Judge Posner happens to agree with me. And he made a great argument about that once. He said, if the voter ID laws were truly intended to increase the degree of voting by minorities, something that conservatives on the GOP and Libertarian and Tea Party side have claimed, if that was the goal of these laws, then conservatives would oppose them and liberals would defend them. In reality, liberals oppose these laws because they undermine the voting rights of minorities, and conservatives support them. So there you have it. If conservatives really thought this would improve minority voting, they would oppose these laws. But since they don't oppose them, since they support them, they must be reducing the voting of minorities. Because the one group that the GOP does not want voting are minorities, because minorities almost always vote against the GOP. So there you have it, folks. A little synopsis about what sovereign citizens are. These people have a very unusual interpretation of reality. They're pretty much unhinged. It's very much magical thinking, that if they use these particular words in a particular combination, they will be able to free themselves from obligations to the federal government. It's crazy talk. It's unhinged anti-government mentality. Oh, I have a blister in my hand. So it's fascinating and sad at the same time, and scary because some of these folks do overlap with militia movements, and the FBI does consider some of these sovereign citizen groups and individuals to be legitimate threats to the United States, far more dangerous than actual extremist jihadists. They are considered to be a greater threat to the United States than jihadists are, with good reason, because they are not well attached to reality. So I'll put links to both the Rational Wiki's page and to the article, so you can go get some further details if you'd like. It's fascinating, folks, if terrifying as well.